Okay, so again, I'm Dave Strifling from Marquette Law School. I'm the director of something we call the Water Law and Policy Initiative. I'll tell you a little bit about that and what we do. First, of course, we're here primarily for our students. So I teach courses in water law and environmental law, natural resources, land use planning, all those kinds of things. And of course, we have other related courses for them to take as well. We have a robust externship program that places students in the legal departments at the Wisconsin Department of Natural Resources, Midwest Environmental Advocates, the Milwaukee Metropolitan Sewerage District, among other places. We have an active environmental law society. We have moot court teams participating in environmental law competitions and all sorts of other things. We do public events periodically. They're all free. They're all open to the public. We do a newsletter that announces all those. If you want to get on our mailing list, you're welcome to email me. It's just david.strifling@marquette.edu. And you can find me easily enough online as well. We collaborate on lots of projects with folks inside and outside the university. Water is a major focus for us here at Marquette. We've got engineers and education folks, political science, economics, biology. I'm sure I'm missing some. Even our art museum has done water-related exhibits. So we work with a lot of those researchers and then those outside the university as well. We've collaborated with others at UWM, the City of Milwaukee, the DNR, MMSD, the Water Council, all sorts of places. So we welcome those kinds of opportunities too. And then finally, we do typical academic research. Some of it is funded, some of it is independent. And you'll hear about, of course, one of those projects today with our research into legal and policy strategies for chloride management. So that's just a little introduction to who we are and what we do. We're totally nonpartisan. And so, what I'm presenting today is just a menu of options for policymakers. We're not saying that there's any one-size-fits-all solution to this issue. Obviously, it's very complicated. So it's just a menu of options that we've come up with. So I said this one was a funded project, and I want to acknowledge that this research was made possible by a grant from the National Science Foundation through something called the Industry University Cooperative Research Center for Water Equipment and Policy. That's jointly operated here at Marquette and also at the University of Wisconsin-Milwaukee. And it's a little bit unique in that the center does a lot with sensors and materials and contaminant detection, those kinds of technological things, but it also has a focus on policy, which is where I come in and where this project comes in. So thank you to that research sponsor. And what I'm presenting today largely comes out of a paper that I wrote about 5 years ago. I've got just the first bit of it on the screen here. It was published in one of the environmental law journals. And if after hearing the presentation today, you're interested in learning more about the legal and policy side, I'm happy to provide a copy of the paper to you via email. Just reach out and I'll be happy to respond with that. What first attracted my attention to this problem is what I wrote in the first line of the paper here, that usually when we talk about greater environmental protections and increased public safety, they go hand in hand. So, we have the Clean Air Act. People have better health outcomes because they're breathing cleaner air. We have the Safe Drinking Water Act. People are healthier because they're drinking cleaner water. But this is a case where those two goals might be in tension. For example, as I've said in the paper, when the excess application of salt for de-icing causes elevated chloride concentrations in waterways or groundwater or wetlands or soils, and we have adverse environmental outcomes as a result of that. So it's a really interesting, difficult problem, both, of course, from the technical and the legal side. And I think that's what makes it so interesting to study. So first, I wanted to talk just a little bit about the technical side. I'm an engineer, a civil and environmental engineer by training, and practiced in that field for a while. So I tend to choose projects that have some technical aspect to them. And I think it's important to try to bring the two fields together, as I'll talk about a little bit more momentarily. So what I've got here is just the USGS decadal change in groundwater quality map for chloride. And it won't be any surprise to anybody on the call to see that it's up just about everywhere there is data, more in some places than in others. But certainly we're seeing a general trend here of an increase in chloride in groundwater. And I think the same would be true if we had the surface water map up as well. So the project approach that we took was first to conduct a literature review to understand the extent and cause of the problem from the technical side. Obviously, we're a legal shop. We don't have the capability to go out and collect additional data, but we can certainly try to get a grip on what others have done in that field, and I'll summarize that in a moment. Then and only then did we try to identify and develop the legal side, the potentially responsive legal and policy options. And we analyzed those using various metrics. And those could include, or did include, environmental effectiveness, cost, implementation difficulties, political aspects, a variety of things. So first, the literature review. And again, I know that most of you on this call will be very familiar with this info, and Allison did stress that I shouldn't spend too much time on this, and I promise I won't. But I just want to let you know the base of information that our team was starting from, and maybe we missed something that you can fill me in on. But here's what we found when we summarized the literature that's out there, and of course, there's a lot more of this in the paper. But certainly there are environmental impacts, health impacts from elevated chloride concentrations on ecosystems, on water quality, on human health. And so we documented some of those. Of course, elevated chloride concentrations max out during the winter months, the salting season, but we see them during all seasons. And that's a result of sort of a dual release process, I think, to the environment. A quick release when it's washed off of surfaces to impervious surfaces, that is, to waters and soils. So that's where we see the highest sort of hit or charge in the winter months. But chloride input, as I've said in the next bullet, continues even during the spring, summer, non-snow periods due to its retention, and then a slower release in and from groundwater and soils. So this is not just a winter problem, is the lesson there. And then, so I think the lesson for law and policy from that bullet is we don't want to just transfer salt from surface water to groundwater, because then it's still in the environment. It's still an issue that we have to deal with. And the final bullet talks about how long chloride concentrations persist in watersheds after release. 40 to 70 years, some study has shown. Even if we shut the faucet off now or greatly reduce our input, the legacy chloride that's out there is still going to be causing a problem decades from now. So you hear these analogies, right? When you're talking about carbon dioxide, the first thing we need to do when you got a full bathtub is shut off the faucet, or if you're in a hole, stop digging is the first step. That's similar here, that we're already kind of in the soup here based on what's in the environment now, and that's going to persist for some decades. The other important lesson we learned was that this isn't a one-size-fits-all problem. It doesn't have a one-size-fits-all solution. The impacts of various chloride sources are localized. So the Madison Sewerage District did a study in 2015 that showed that the chloride in that watershed was primarily coming from water softener uses. Other studies tend to show that it's overwhelmingly a problem of road salt. So just more reinforcement for our decision not to recommend one particular strategy for every option.
I wanted to clarify there, Dave, that
Yeah.
the Madison Metropolitan Sewerage District numbers aren't looking at how the amount of salt showing up in the watershed, but the amount of salt showing up in wastewater. So water softening salt isn't going directly into, the lakes in Madison.
Yep,
So
very good clarification. Thank you.
Yeah.
So even if the chloride gets to a wastewater treatment facility, even though we know a lot of it is conveyed directly to waters via non-point sources, even if it gets to a facility, it's difficult to remove. Again, as many of you probably already know, it's highly soluble. It doesn't readily settle. Our bugs don't eat it very readily. And talking to some folks who are familiar with this, they've suggested that ultrafiltration may be a possibility, but of course, that's very expensive and maybe not feasible to refit many of our treatment plants with that kind of technology. So it's really a difficult problem and tends to pass through a lot of the treatment facilities pretty easily. So there we are. We've got lots of studies and evidence that we have elevated chloride concentrations in our waters. That's well established, as are the adverse effects of that on the environment and on human health. But very few efforts, at least in my estimation, made to establish policies or laws to control that, to control this issue. So we know this is an issue, but we haven't done much about it, is the short answer. And why is that? Well, again, there are lots of public safety concerns involved here. Public perceptions, I think, are an issue. Availability bias, meaning in shorthand, sort of out of sight, out of mind, that everybody knows about ice on the freeway and ice on sidewalks because we see it. We live in it. We live in this environment. But we don't necessarily all see the harm that's being done to ecosystems, to soils, to surface waters, to groundwater. And so that's not something that's on the radar screen for a lot of people. Inaccurate weather forecasts, I think, play a role. The affordability and effectiveness of salt is something that I'll talk more about, but that certainly is on the list. And then perhaps the thing that I get asked about the most is the liability concerns. And surveys have been done of salt contractors, de-icing contractors, and this is always high on their list of concerns, if not topping the list. Slip and fall cases and liability, especially on private property, where you're not shielded by any kind of municipal immunity or liability limits. This put it all together, and this has led to over application of salt, I would say, being what many contractors view as the safe strategy or the safe thing to do. And this private property issue is important, really important, because we have other studies that show that up to half of all chloride application, salt application, is done on private property, large commercial parking lots, driveways, private roads, sidewalks, that type of thing. And so this is a part of the issue that I think hasn't gotten as much attention and that we need to focus on as well. Okay, before I get into the menu of options that we developed, I do want to talk about one other issue first, and that is a reason why over-application may no longer be the safe strategy, and that is the Resource Conservation and Recovery Act, or RCRA, as you may have heard it called for shorthand. This is the law that is intended to remedy issues caused by inappropriate disposal of waste, and it covers both solid waste and hazardous waste. The aspect of it I want to focus on is that it forbids open dumping of solid waste. So it does authorize citizen suits under some circumstances. Anybody can bring suit under CERCLA. You don't have to wait for the RCRA, rather. You don't have to wait for the government to do so if you think there's been a violation. And that happened with respect to chloride. A citizen brought suit against the city of Omaha. This is going back about 5 years now, alleging that the city had violated this prohibition against open dumping by applying excess de-icing salt to streets. And some of these facts will sound familiar perhaps to some of you. Some of the streets are in a floodplain and may not have curbs or storm drains. The city was not removing any of the salt post snow events. It was just remaining there until it was carried by runoff off the road. The citizen also alleged, and it was uncontested, that chloride is hazardous to wildlife and land and water resources. So the question for the court was, does over application of road salt, de-icing salt, constitute open dumping of a solid waste, at least potentially under RCRA? Solid waste is defined very broadly. That's not a particular issue. And when courts look at the question of, whether it's open dumping, they ask whether the particular product has served its intended purpose and is no longer wanted by the consumer. And the key question there is whether the user has discarded the product, whether it has served its intended purpose and is no longer wanted. Then it's a waste. EPA has put forth its own test in a regulation defining discarded as abandoned, among other things. So is road salt that's just left there after a snow event or an ice event discarded or abandoned? That's the question. And play along with me here, a little game that we can go through. I do this with my classes all the time. Which of these fact scenarios do you think involve something that is discarded and a solid waste, such that a liability can result under RCRA? These are all taken from actual court cases. How about pesticides sprayed onto or into the air or onto the land or water for mosquito control? Court said no to that one, that there was no liability in that case because the product was being used for its intended purpose. How about wood preservatives that escaped from treated utility poles through normal wear and tear over the years? Again, the court said no RCRA liability in that case. How about manure applied excessively to farm fields as a fertilizer? Really interesting decision here. This comes out of a federal court in Washington State. The court said yes, potentially, if not done in accordance with the nutrient management plan, has clear implications for some areas of Wisconsin. I think that could qualify as open dumping of a solid waste, such that RCRA liability could result. So how about road salt applied to roads as a de-icer, perhaps excessively, some might say? The Omaha court in Nebraska said no, at least for now. And the reason was a finding that the city hadn't abandoned the salt. It was just being applied to the land in the ordinary intended manner of use. My reaction to that is that's got to have some limit, right? If you're just dumping huge piles of salt, certainly that could lead to liability, but we don't know yet where that line is. And I'm not sure how this fits with the manure case that I just talked about. The argument wasn't made in the Omaha, Nebraska case, so maybe that'll come in a future lawsuit. Okay, getting now to our work. These are the kind of categories of policy options that we developed. Incentivized self-governance, this is sort of anti-liability programs, as you'll see. Information dissemination, things like SaltWise. Direct regulatory strategies, things that DOT or DNR or local municipalities could do. Chloride alternatives like green infrastructure or some of the alternative chemicals that are starting to come into use. Integrated watershed management, and direct economic measures like funding sources or taxes that can affect how much salt we use. So I'll go through just briefly each one of those categories. Incentivized self-governance, to start out with that, this I think is the most powerful one, the most interesting one. And we've got one good example of it. There's a program in New Hampshire that's based in a law that was passed by the state legislature that provides contractors with a certification after training on best practices for snow and ice removal, how much salt needs to be applied, spread rates, those kinds of things. And if you go through the training and you get the certification, you get a liability waiver from slip and fall liability. Now, you have to show that you weren't grossly negligent, that you didn't show reckless disregard, that you followed the proper procedures. But if you did, you are immune from slip and fall liability. And so is, and this is a key component as well, so is the owner of the property where you applied the salt, where you did your work. So, if your XYZ contractor is applying salt to the Home Depot parking lot, both of those entities are immune from slip and fall liability. Again, absent a showing of gross negligence or reckless disregard for safety. So it's got some obvious advantages, efficiency, while balancing some of the concerns that we know exist in this arena. There's the environmental hazards of chloride on one hand and the public safety concern on the other, and you throw in the financial issues associated with slip and fall liability. That's kind of a tightrope that we're walking from a policy standpoint. And, it's just like anything else. It seems unreasonable to assume that we're going to be able to drive 65 miles an hour on the highway shortly after a snow and ice event, or even in some cases during one. But that's sort of the expectation that a lot of folks have. And similarly, we've got to balance that concern here of environmental hazards versus public safety versus liability. That's not the only advantage, though, I think, or that I want to mention. There's also a cost reduction to municipalities, contractors, private users due to decreased salt usage. There are marketing advantages. I've pasted on the slide here in the middle right the badge that certified contractors get to use on their marketing materials, and we know it's been demonstrated that there are advantages to green marketing approaches. And there are potential insurance benefits as well. Some contractors and property owners have even seen their commercial insurance rates fall as a result of being certified under this program. There are some challenges here as well, and I don't want to leave out that part of the story. When I talked to the folks running the New Hampshire program, their biggest concern was funding. We need staff to run this program, to monitor the training, to process the reports that come in from contractors about how much salt they're using, which is a key part of the program here. So there are a variety of ways that the need for funding comes into play. It's voluntary. Not all contractors are doing it. The difficulty of initial passage is big. Of course, there are segments of society who don't like this idea of taking away the case for slip and fall liability. They think that when someone is injured, they should be compensated for that. And I acknowledge the force behind that argument. So that's an issue with this, is you've got to get it through the state legislature in whatever state you're in. It's been tried in a couple of other places, and I'm still only aware of New Hampshire as a place that it has actually been written into law. And then finally, there have been some complaints from contractors who have objected to the obligation to file annual reports of the amount applied. That's something that the program wants to see, with hopefully a decrease every year in the amount of salt that the certified contractors apply. It seems like a pretty small complaint to me in exchange, when you're considering what you're getting in exchange, the immunity from a slip and fall liability, but nevertheless, there have been some complaints about that. In the first years after the program was put in place, the government was able to demonstrate a significant decrease in salt use with corresponding cost savings up to 30% less per the first annual report. And they were monitoring chloride impaired watersheds and showed some improvement there as well. They got hundreds of participants certified, but as I've already discussed, It's difficult to replicate this elsewhere. You need champions in the legislature. You need early adopters in the regulated community. You got to have the liability waiver for it to really work. And as Allison mentioned at the beginning, there are some preliminary efforts going forward in Wisconsin on this front, but nothing that I would say is, going to happen tomorrow or in the next few months. Okay, information dissemination. This is a common strategy with environmental problems, and I've used SaltWise as the perfect example of that. I've even pirated one of the SaltWise drawings at the bottom here. Sorry, Allison. But these are attempts to educate the public about de-icer usage, what the effects of this are on human health and the environment. And it can be strategies to educate the public at large or strategies to educate chloride users. It can relate to road salt, it can relate to water softener usage, but these kinds of public information campaigns, I think, have the potential to be really successful. And, they don't have to be, there's no similar difficulty to the liability waiver. They don't have to be enacted into law or get through the legislature, anything like that. They're just informational. So this kind of thing, I think, can be really helpful. Direct regulatory strategies. So these are actions that could be taken by state, usually environmental agencies, or also transportation agencies. So that would be the DNR and the DOT if we're talking about Wisconsin. And so, the first thing we observed in looking at this is it's pretty rare to see any regs that set best practices for salt application. More common to see regulations governing salt storage when you look at the different states. Whether it has to be covered, those kinds of questions, how large piles can get. There are some regs that apply to those kinds of situations, but not much on application. You could also require reporting requirements, reporting rather, of the amount used by contractors or by municipalities or counties. That could be a regulatory strategy that you could take. And again, like New Hampshire, hope to see a reduction from year to year. You could mandate or suggest the use of alternative chemicals. Everybody loves to hear about beet juice and cheese brine and those kinds of things in Wisconsin. I will say that those alternative chemicals often have adverse impacts of their own. And so there really needs to be a risk versus risk analysis undertaken before we just uniformly endorse the use of some chemical that's an alternative to salt. Road and weather information systems. This is practiced in Wisconsin, of course. You could mandate anti-icing or pretreatment methods. And then uniform spread rates. This is something that I was absolutely blown away by when I was writing the paper, how different states, different DOTs, at the same weather conditions have vastly different guidance about how much salt to apply. And I've given some examples there at the bottom of the slide. Of course, the different DOTs have varying recommendations at different temperatures and different snow conditions, snowfall rates. But here I just pulled out the exact same weather conditions, 24 degrees and light snow in 3 different states. And you can see they're all over the map. So this is a place, I think, where some kind of guidance from the federal DOT could be helpful, or the states could get together and talk about this. But it just doesn't seem logical to have rates this different at the same weather conditions. DOT could also put forward some level of service expectation adjustments. I don't think that's too likely as a possibility, but again, it goes to what our expectations are about driving in the middle of winter storms. I want to talk a little bit about the Clean Water Act and what DNR could do with that. You could have chloride limits imposed during permitting under the Act. So Wisconsin does have water quality standards for chloride. I've listed them on the slide. But DNR has said that most wastewater treatment facilities just aren't able to meet them, especially the chronic value or criterion. So variances are possible, and often used in WIPD's permits for municipalities, especially. You see rates that are 500, 600 milligrams per liter. And part of that is a recognition, which has actually been written into the DNR regs, that source reduction is really the way to go here, not end of pipe treatment. So there's lots of incentives written into these permits to get the municipalities to pursue source reduction activities rather than holding their treatment facilities to the fire and requiring end of pipe treatment.
I have to pop in here again, Dave.
Yeah, go right ahead.
Since yeah, I work pretty closely with the Madison Metropolitan Sewage District. My understanding is there are, I think it's just over 40 wastewater treatment plants in Wisconsin that aren't consistently able to meet the criteria that the criteria in the DNR has set, and so operate under a variance. But my understanding is that that's not most. I think are there like hundreds of wastewater treatment plants? I'm not sure, but just 40 that consistently put out more chloride because they're receiving so much from water softeners primarily. And it's wastewater treatment plants that are in southern, kind of going up like southeastern Wisconsin, where we have that limestone, dolomitic limestone bedrock. So hard water that gets softened. So yeah, I just want to check in on that most, unless you have some information that I'm unaware of.
Yeah, that's probably more precise. I don't have the exact numbers in front of me. We just pulled out several of the ones with variances and some of this language from the code that I've got on the screen here, but I do not have the exact numbers, and I trust your information on that.
Okay, cool. Yeah, I just wanted to jump in there, but
yeah, thank you.
Right.
Thank you. Only other thing I'll mention about the Clean Water Act is there is the potential for a TMDL, a total maximum daily load for chloride. This is something that would happen if Wisconsin put one of its waters that is impaired for chloride on a 303D list under the Clean Water Act, and then developed TMDL. That would allow it to assign allowable loads both to the point sources and the non-point sources that feed that watershed. It's something that's been done in Minnesota, in the Twin Cities prominently, metro area. I'm not aware of any place in Wisconsin that has a TMDL for chloride, but it is a tool that would be in DNR's toolbox. A long and expensive process, however. You could also have municipal ordinances and initiatives. So for example, the city of Madison has a, I believe, pretty new ordinance, although Allison, you can jump in here too if I'm wrong, that limits property owners to the use of reasonable quantities of salt to the extent necessary to allow safe travel. There's some interesting language here. The timing of application, allowable application, is restricted to when ice is present or imminently likely to form. Another feature of the ordinance is that you have to, the property owner rather, has to remove the salt promptly following ice melt. The only thing about this is it's a municipal ordinance, so the fines for non-compliance are pretty small. And at least as I read it, it applies to sidewalks. I'm not sure if any efforts are in the works to make it more broad than that, talk about parking lots or private roads, but go ahead, Allison.
Yeah, I can pop on just briefly. So the city of Madison just passed an ordinance several weeks ago, I think at this point, and it is just limited to public sidewalks. So it's public property, so they can kind of regulate their own property that's maintained by private residents, companies, etc. And I know that there's this city engineering department is working on putting out a podcast about this. There's going to be a press release coming out soon. But the first kind of, this will be, the first winter with this, they want to really just kind of focus on education and letting people know that excess salt, one, is not doing any good, two, is doing harm, actively doing harm to our waterways, your property, etc. So education first. And then, yes, there is, I think it's like a $50 fine that can be assessed by a building inspector if it continues to be a problem on the property. But my understanding is that there haven't been any fines assessed at this point. Just trying to keep it educational.
Yeah, great. Thank you. Okay, alternatives. I want to talk a little bit about green infrastructure here mostly. And I know that folks have had mixed experiences with it, permeable pavements especially. And there are concerns about the long-term utility, the initial capital cost, and those kinds of things. But it is something that I wanted to put on the list because we do have studies showing that permeable pavements in particular reduces salt application requirements by up to 75%. And the issue, of course, here is stopping water from pooling on the surface. If ice forms, doesn't matter if you have green infrastructure underneath, you still got to put the salt down, and all you're doing is transferring the problem to groundwater. But if the water filters through at first so that you don't have ice, you don't need to apply salt in the first place, I think that's where these gains are coming from. So there are studies out there that show these cost savings and salt application requirement reductions associated with a variety of permeable pavement technologies, but a variety of green infrastructure technologies, but especially with permeable pavements and bioswales. I do recognize the challenges, the costs, the public resistance, perhaps because of negative experiences with green infrastructure, and the potential, if it doesn't work right, to transfer chloride to groundwater. I think the cold hard truth with green infrastructure is you've got to maintain it. It's not sort of set it and forget it. Even if it's a bioswale or something, you've got to maintain it over the years, and that's a challenge that some don't want to take on. So there are issues with it, but it is another potential strategy. Integrated watershed management. This is something that I think is a buzzword. We've all probably heard it, whether it's IWRM or IWM. It's something that gets a lot of attention. I think a lot more work needs to be done to figure out the details and how it's put into practice. So it's usually defined as coordinated development and management of water and related resources for societal benefit without compromising ecosystem sustainability. So you've got multiple agencies, multiple jurisdictions working together, and that can be vertical, like a municipality and a county and a state, or it could be horizontal with multiple municipalities in the same area, working together to address a broad range of water issues, information sharing, informal planning, shared management, even in a few cases. It's a flexible process, typically allows for adaptive management, and as I say here, it can complement traditional approaches. I do think there are some big challenges here too. I've always thought it's quite vague in terms of exactly what is intended, what it means, how do you fund it. There are some legal roadblocks as well, in that certain entities have legal responsibilities to manage waters within their jurisdictions, and so there's some obvious resistance to giving that up. But this is another approach that could be a possibility if we can get the details right. And then finally, the last one I want to talk about is direct economic measures. Of course, this is just a simple question of supply and demand. You may recall there was a winter several years ago where the cost of salt went way up and we had to get it from several states away. That year was one of the lowest salt application years in memory because some municipalities just ran out of salt, couldn't afford to get more. And so the rate of use went way down. When you talk about those kinds of scenarios, though, or even worse, the T word, putting a tax on something to generate funds for water resources management, that's not going to be popular, politically unpalatable. I've put on the slide. You could have, as I've used Iowa as an example here, and some of the proposals that were put into play there. You could have a minimal increase in the sales tax and apply a portion of the proceeds to water infrastructure. You could fund water quality programs out of a water metering tax. But again, these aren't things that are going to be popular, although they have been successful in some places at generating money for water quality improvements. I don't have any concrete examples of it being applied to chloride reduction, however. It's just, again, something that we wanted to put on the menu, even if the likelihood of implementation is somewhat low. And then finally, I wanted to mention the bipartisan infrastructure law and some of the other major bills that have gone through Congress in the past couple of years. $55 billion to expand access to clean drinking water, for example, and $110 billion for roads and bridges. I don't know that any of that money has been earmarked for chloride reduction or earmarked really for anything at this point. A lot of it is still TBD as far as I can tell. But that's another potential source of money to do things like refitting trucks or promoting educational efforts or underwriting regulatory efforts. Any of those would be possible in this arena, as I've discussed already. So what did we do with this research? We didn't want it to be just academic, white paper sitting on the shelf in my office kind of thing. We did partner with the Milwaukee Metro Sewerage District, the City of Milwaukee, Sewer PAC, the Southeastern Wisconsin Regional Planning Commission. We gave numerous presentations on this, both me and my students. And so we tried to get the word out as much as we could. I will mention one last thing before I open it for questions here. And that is that the Southeastern Wisconsin Regional Planning Commission is in the middle of a monumental study on chloride management in the Southeastern Wisconsin environment. Done tons of monitoring, writing lots of technical reports. I've been towed in to be part of the technical advisory committee and write a short report on these legal and policy approaches to managing chloride. But there's a great website that the commission has. It's got a lot of data online. If you're interested in this topic, highly recommend learning more about what Sewer PAC is doing in this arena. And finally, I'll just put up my contact information before I stop sharing. If you do want to get in touch with me to talk about any of these issues more, I certainly welcome that. Easiest way to grab me is probably by email, david.strifling@marquette.edu. So I went a little bit longer than anticipated, but I think we've still got plenty of time for questions if there are any, Allison.
That's great. Thank you so much, Dave. You are totally fine. Yeah, I'm going to type your email into the chat here for folks. Since we can't put that screen away and have our faces up, or have both up at the same time. So david.strifling@marquette.edu.
Yep, you got it.
Okay, great. So that's in the chat now. And we have some questions already queued up here. So
Great.
It looks like some comments and questions. So Catherine, my colleague at Madison Metropolitan Sewage District, did just want to, again, emphasize that the MMSD study doesn't quantify watershed balance, just the wastewater treatment plant effluent. So it is being released. All those salts are also going into our freshwater because we can't pull them out. It's not really feasible, but yes, we'd have to add in kind of all the road salt that's coming in as well to kind of look at the full picture there.
Yep,
so,
thank you for that.
Then we have a question from Kay Gerwin. Can you share more information about the manure case? So just a little bit more there. And one particular question I had on that, Dave, was, did that ruling happen before or after the Omaha case? So I don't know if you want to kind of just dive into the manure case just a little bit more ways that, what we can learn.
You're testing my memory here during exam season. It's been a while since I've read the case, but I can say a couple of things. One, pretty sure that the manure case did come before the salt case in Omaha. The Omaha case, I don't know if I made this clear enough, but the citizen represented himself, which any lawyer will tell you is not a great idea. And so he did not make the argument based on the manure case in the Omaha case. And so I think there's that potential in the future for somebody to do that and claim that.
Focus on the excess. This is not needed.
Not the fact that you're doing it. I mean, of course, and this is a point I probably should have made more clearly. I'm certainly not arguing for the elimination of road salt. I don't think anyone is. What we're talking about here is optimization or efficient application of salt. And so, that's where I think the argument is a little bit flawed, that, the citizens sort of made it easy for the court to say, well, of course the city is doing this. They're just, putting down salt to melt ice, and any city does that. No, that's not the argument that should have been made there, at least in connection with the manure case. What we're really talking about is the excess application, not just the base level that's needed to melt ice. A little more detail about that case. I think this, again, I don't recall every detail of it, but this was a case where the manure spreading was either being done without a nutrient management plan in place or in excess of the limits that were set in the nutrient management plan. And so it was easier for the court to take that excess argument and say this is more than the land can accommodate. There's a lot more detail in the case in terms of the actual numbers in the plan versus what was actually being applied. But it was a little bit of a shocking decision, actually. I don't think anybody expected the case to come out the way it did. And ultimately, I think the applicator settled rather than appeal the ruling to a higher court. So the case is still on the books.
Very interesting. And that kind of leads us into the next set of kind of questions, comments here about application rates. Catherine Harris mentioned that, well, first she said, like, are the weather conditions different in different states? But I think you were clarifying it was the same temperature, right? Same pavement temperature, same type of precipitation, light snow, and very different rates.
Right.
Catherine is though bringing up like maybe the condition of the roads or the types of roads. I know like different like levels of service in Wisconsin, kind of require different amounts of various types of treatment or other factors there that might be different.
Those are all good observations. I don't recall any of those being made in the source material. But again, it's been a little while since I looked at those documents, and they could have been updated to account for those kinds of things. But my recollection is no, that they were just pretty basic in terms of their recommendations. They had down particular temperatures and weather conditions, and that was about it. Yeah. And even if you account for level of service or road surface type, I mean, the differences here were like a factor of 3, right? I mean, it was not, a difference of 80 versus 90 or 100 versus 110 per lane mile. It was very extreme differences between states.
Yeah. And I mean, even I think just the Wisconsin rate that you shared there, like between 100 and 300, like,
right.
That's huge, right?
Yeah,
And I think that's where, I mean, right now we have such a gap, and I don't know if necessarily in terms of knowledge, but in terms of willingness to, put a recommendation out there, right? For manure, we can look at, okay, it's this soil type, it's this slope, this is the current kind of phosphorus, concentration in the soil. You can only apply, like, I should not come up with a number of like pounds of phosphorus per acre.
Right.
I've been out of that for way too long, but we're not there, right? With salt. We don't have that kind of direction kind of from the top down, like you said, the USDOT, right? And I think even those numbers that you shared that are out there, like some sort of a recommendation for solid rock salt, like when we move now to liquids, liquid brines, it's like we don't even have that. So people are really kind of left, municipalities in Wisconsin, it's the counties that maintain our state highways, they're kind of left on their own to be like, figure it out, try this, see what works for you, right? It's like we don't really want everybody trying to reinvent the wheel and figuring it out when we have a lot of knowledge. So yeah. Anyway, I will cut myself off here.
No, I agree 100% with everything you just said.
So, okay, we've got another question here. Is the WPDES, so that's the Wisconsin Pollutant Discharge Elimination System, right?
Yep.
So just for everyone who's not in the industry here, the WPDES permit applicable only to publicly owned treatment works permits, or is it also implemented through stormwater permits?
Yeah, so the answer to that is it's applicable to point sources. And those can be public or private, but we're not going to be usually rolling in non-point sources, stormwater flow. In some cases, there are MS4 permits that are rolled into that. I'm not sure how much they can consider chloride, but for the most part, we're talking about wastewater treatment facilities, public or private, when we're talking about WIPD's permits.
All right, well, those are the questions that I see right now. We'll just wait a second here, since I know there is a little bit of a delay. While people are waiting, I will take a minute to promote Wisconsin Salt Awareness Week, our next set of webinars happening January 23rd through the 27th. We've got our lineup for that. We're really excited to kick the week off with Sujay Kashal from University of Maryland, speaking about freshwater salinization syndrome. So yeah, you can check out the rest of the lineup online and actually register for that. And then I will share probably in the next month here, the rest of the plan for kind of Wednesday webinars in 2023, or the first half of the year. So yeah, but Salt Awareness Week coming right up. All right, so we've got another question here. Dave, many of your examples were for policies to limit road salt. What ideas, if any, do you have for policies to help minimize water softener discharges?
Yeah, great question. We do have a section on that in the paper, focused more on road salt here today, but there are ideas for water softener control. Some cities in California have just banned them. That's sort of the most extreme position that someone could take. I don't see that as a widespread solution, but that is something that's been done. The other idea is, again, just optimization and, having softeners that refresh or recycle when needed, rather than just doing it once or twice a day, as many older softeners do. And that's the key to less salt use. Now, how do you do that? How do you get the homeowner to replace his or her old water softener that just recycles twice a day with one that does it as needed? That's not easy. And that's where you need some kind of, number one, informational effort to persuade people that it's the right thing to do. And number two, probably some kind of financial support, whether that's a rebate program funded somehow or a cost share, something like that. So my recollection is those are the strategies we looked at in the paper, ranging from the extreme to the at least somewhat possible, but agreed, in some places that is a pretty big component of the load.
Mm-hmm. All right, thank you. Yeah, no, my aunt, just an aside here, my aunt lives in Los Angeles and they have hard water, but they've got like no water, right? And so they're not able to soften. She drove through Wisconsin like last winter and was just like, what are all these bags of salt out for? Like, what are you guys doing with salt? It's the summer. She could not believe that we use salt to soften water. All right, we do have we got a thank you for the excellent info, Dave. And then
You're welcome.
Someone had said at least some of the MS4 communities are required in their permits to report how much road salt they are applying. So I guess maybe more of a comment there. And I believe that's just started in the last few years. Do you know, Dave, is that correct?
Yeah, that's something that DNR is just beginning to share data on. So I know it's a new program. I'm not sure exactly when, but that is some data that we can use.
Okay. All right. Another question here. Have you looked at any changes to plumbing codes that would mandate softening less water? For instance, like you could only soften hot water.
That is not something that we looked at. We did not dig into plumbing codes. That's a good suggestion. I think it would be difficult to enforce, but it's a good idea.
All right. Another question here. See, aren't you so glad, Dave? I bought us some
They're flying
time.
in.
You get to stay on, keep
that's
procrastinating on reading those papers. All right. What policies are being done on the materials science side? For instance, like permeable paver example that you shared. related to road building and high-risk ice areas. So policies done on the material science side related to road building and high-risk ice areas. Seems like changing infrastructure could reduce salt use.
Yeah, I agree. And that's an area of low-hanging fruit potentially. I think, again, the key is preventing ice from forming in the first place rather than letting water pool on the surface. I'm not aware of many, if any, requirements for green infrastructure. There are some building codes that do require a certain amount of green infrastructure depending on the size of the development. But in terms of highways or road building, not much of that out there. And again, that's another potential area for improvement. And a lot of work has been done, including a little bit by me, on looking at what the barriers to green infrastructure are. And certainly that's one of them is, the lack of a requirement to use it at scale. We see it on a lot of smaller projects, but really nothing at any large scale. And there are a lot of reasons for that. Number one, it's not required legally, but also the capital cost and the distrust of it by the public as compared to, a good old tried and true gray infrastructure, curb and gutter type of thing. That's what people know, and so that's what they trust. So a lot of work to be done there, I think, to win hearts and minds, but also quite a bit of potential.
All right, thank you. And that's all that I see, Dave, for right now. So
okay.
I'll just pop on one more time here. But yeah, I just want to thank you again so much for coming on and sharing your research with us. Sue Nissen did just share that Connie Fortin is working on building for less need for chloride. So working on that kind of design aspect at Bolton and Mank out in Minnesota. So just an update there for folks. I think it's low salt design, something along those lines. Cool. But anyway, always more happening, right? We got a lot of great brains working on this problem. So thank you for being one of them. And thank you again for sharing your time with us. And again, people can reach out to Dave or reach out through me if you have any other questions. But until then, I guess, happy holidays and happy new year.
Yeah, thank you for having me. It's been a pleasure, and happy holidays to everyone.